Alright, this is October 1st, 2024. Members of the jury, the evidence and arguments in this case have been completed, and I will now instruct you as to the law, period. The law that applies to this case is stated in these instructions, and it is your duty to follow all of them. You must not single out certain instructions and disregard others. It is your duty to determine the facts and to determine them only from the evidence in this case. You are to apply the law to the facts and in this way decide the case. Neither sympathy nor prejudice should influence you from time to time, It has been the duty of the court to rule on the admissibility of evidence. You should not concern yourselves with the reasons for these rulings. You should disregard questions and exhibits which were withdrawn. I think it's in order to which objections were sustained. Any evidence which was received for limited purpose should not be considered by you for any other purpose. You should disregard testimony and exhibits which the court has refused or stricken. The evidence which you should consider consists only of the testimony of witnesses and the exhibits which the court has received. You should not consider all of the evidence in the light of your own observation, experience in life. TPH. Neither by these instructions or remarks which I have made to you do I mean to indicate any opinion as to the facts or as to what your verdict should be. Faithful performance by you of your duty as jurors is vital to the administration of justice. Only you are the judges of the believability of the witnesses and of the weight to be given to the testimony of each of them, period. In considering the testimony of any witness, you may take into account his belief, ability, and opportunity to observe, his age, his memory, his manner while testifying, any interest, bias, or prejudice he may have, and the reasonableness of his testimony considered in the light of all the evidence in the case. You should judge the testimony of the defendant in the same manner as you judge the testimony of any witness. And opening statements are made by the attorneys to acquaint you with the facts they expect to prove. Closing arguments are made by the attorneys to discuss the facts and circumstances in the case and should be confined. I don't know if it should be or you are confined to the evidence and to reasonable inferences to be drawn from the evidence. Neither opening statements nor closing arguments are not evidence. Any statement or argument made by the attorney is not based on the not based on the preponderance of the evidence should be disregarded. Those who took notes during trial may use your notes. Oh.